introduction. Sorry, as you were saying, I don't know if the next speaker is going to show up, so I'm going to do about 10 minutes of stand-up before I... So yes, as Lalit mentioned, I'm going to be speaking about idea commercialization from an intellectual property or IP standpoint. But before I get into that, such an interesting panel of speakers you had. Just I heard Sunny and Greg speak. It just things were firing in my head. I just wanted to make a couple of comments in general about raising money. Definitely, we do have a funding gap in Toronto and in Canada in general. We've had it for a long time. And we all get tired, people in the industry, because we talk about it all the time. I think, in particular, in the web mobile space, there's a lot of activity that's happened over the last few years. And not to contradict what Sunny and Greg mentioned, I mean, definitely you want to be prepared when you go and pitch an investor. But at the same time, industry to industry, you've got to look at it differently. So, for example, in terms of Sunny's background in life sciences or things where you're dealing with hardware, you may need to have developed the product further and have a prototype or something before you go to an investor. However, what's happened in the web mobile space in particular is we've seen an explosion in the growth of accelerators. And so these are essentially incubators, if you will, where they will provide you not only with money, but also mentorship and advice. And they actually want you to kind of come to them almost at a concept stage. And what they will do is they will actually help form the company, form the product, develop the business, and do everything with you. So you just want to sort of look a little bit in terms of exactly what space you're playing in. And then the other point I wanted to make is, in general, whether you're dealing with angel investors or VCs, what everyone says is, if you have the option to be selective about your investor, or in general, in terms of approaching investors, don't think of it as only taking in money. Think of it as, what we term in the industry smart money or value add money. In other words, your investor should also be your partner, and they almost are kind of a member of your advisory board. They may even take a board seat, but they really are helping you build the business. So don't look for people who are just going to give you money and step back. As an early stage startup, you want to look at people who've had operational experience. That would really be ideal. People who actually are serial entrepreneurs who have run companies successfully before, ideally exactly in your niche sector. So they're not only providing you with money, but they're opening their network, as Greg said, and also bringing their own hands-on experience in growing and delivering, in your particular space. So first and foremost, I guess, the question is, why do we even care? And why am I here speaking about IP in an idea commercialization talk here at the Pi Institute? Well, I think the reason for this is, and Lalit actually originally approached me to talk about IP strategy at a future session, and I said, I think about IP either too early or sometimes too late. And a lot of times they miss the time frame where they really should think about it carefully. And the reason is, when you look at really what idea commercialization is, which is the business that all you folks and other entrepreneurs are in, really, when I try and simplify it, I look at it as there's two prongs. You're either looking to commercialize an invention, and so by an invention, I mean that you basically invented a new technology. So you're either looking to commercialize that, productize that, or, and it could be a combination of these, you're looking to actually apply an existing technology in a new market. So either of these two paths, they could be two separate paths, or they could be combined. So if you think about, for example, some of the life science companies, a lot of times they're really looking at new invention or new technologies. In the web mobile space, there's tons of companies right now that are getting venture funded, and they're not investing in inventing any new technology whatsoever. They're actually just taking existing technologies and just applying it to new business ideas or new markets. So what I want to leave you with as tip number one, and I'm going to try and leave you with a number of tips so you actually take something away from the talk today, is that think of intellectual property or IP as basically a commercialization tool. Okay, so don't look at it as that's something that lawyers do. It's a part of your toolkit for commercializing your idea, and it's actually a toolkit or a commercialization tool that should be customized based on exactly what your particular idea commercialization is, or as I put here, your idea mix. So If you're just really looking to commercialize a new technology, your IP strategy might be different versus if you're just attacking a market based on existing strategy or whatever the combination might be. So the point there is look at IP as part of your overall business strategy, and when you invest in it, you're going to look for maximum impact in terms of aligning it with your overall idea commercialization. So with that said, let's talk about a few forms of IP, and I'm going to talk about 3 different types of IP. The first one is trade secrets, and it's very evident from the name itself. What is a trade secret? Well, trade secret is basically you're protecting an idea by keeping it secret. Okay, so what kind of ideas could you be talking about? Well, so again, it doesn't necessarily have to just be an invention or a piece of technology that you're looking to protect. It could be your business plan or a particular market strategy. So, with respect to business plans, what I always tell my clients is, at a minimum, if you're sending around your business plan or providing whether in hard copy or electronic copy, keep a list of the people who provided copies of the business plan to. Track that. You want to mark your business plan with a little confidential or proprietary, information of ABC Inc. In some cases, you may want to even track the number of copies. You might say, okay, copy number 1 went to Sunny Kumar, and CCR copy number 2 went to Greg Roberts. So you're really tracking who's basically had access to the information. How do why do you actually look at trade secrets? Well, one of the first reasons why a lot of startups look at it as a means of protecting IP is because they're operating in what we refer to as stealth mode. In other words, this is before you actually publicly launch or share your product, or if you go to a trade show or present a pitch for funding. You're basically trying to preserve your first to market advantage, and so what you're doing is you're just keeping your idea secret. The other way that you're looking at using trade secrets is not only after you launch, but maybe even post-launch. It's a mechanism for giving you a competitive advantage in the marketplace. So it's just basically saying, this is my secret sauce, right? And that's the example I always share with people is, look at the Coca-Cola, right? Basically a company which is, the formula for Coke is their trade secrets. It's their secret sauce. And that's how they maintain, one of their competitive advantages in the market. Okay, so how do you actually protect something as a trade secret? How do you actually implement that? Well, what you do is, if you're disclosing the information or the idea to anyone, you want to ensure that it's done confidentially, so it's done in confidence. You want to control access to the information, so if you disclose it to a potential, you want to make sure that they don't go and later disclose it to a whole bunch of other people. You want to control access to the information. So I've given you this business plan, this copy of my business plan. It's only for you. It's not for distribution. Don't show it to anybody else. Don't post it on your board here in your conference room for everybody to look at. So you control access, and you also limit the use that they can make of that information. So in other words, I'm providing this business plan to you only for you to evaluate whether you want to make an investment. I'm not providing the information to you to give you knowledge so that you can use it for your own benefit or for somebody else's benefit. This is the use, the limited use that you can make of this information. Now, it's interesting. I was watching the agenda on TVO the other night, and Eric Ries, who's the author of the Lean Startup Methodology, was on. And it was interesting because it got me thinking about how, even from a trade secret standpoint, what we typically would advise clients from an IP standpoint is being challenged by the Lean Startup Methodology. And the Lean Startup methodology is being applied in the web space in particular, which is essentially anti-trade secrets in some ways. So it's about putting out what Sunny was talking about, sort of a minimum viable product out there as soon as possible, and just testing out to see what the market reaction is to it, and then iterating. So not wait until you have a perfect product to put out there, but put something out, see what the reaction is, and then start iterating. That kind of flies in the face of trade secrets, in the sense that, keep everything hush-hush until you perfect it and then go to market, because you don't want to go out with a minimum viable product and have somebody basically look at it and say, oh, that's a great idea, I can do it, and I can throw 10 times more resources at it. And the antithesis of this approach, or I would say probably the person who was most paranoid about using trade secrets, is somebody who's actually been mentioned several times tonight, who's no longer with us, unfortunately, which is Steve Jobs, the founder of Apple. I mean, he's well known for Apple in general, and particularly due to him, is well known for having one of the most stringent, unbelievably stringent trade secret, processes, procedures, and methodologies. I mean, if you look at even a product like the iPhone that is contracted out to contract manufacturers overseas, and you just wonder, how is it possible that that thing was kept undercover? Because that thing didn't take a month to develop. It took a year or more, 2 years. And there was no leakage whatsoever. Nobody knew that this product was going to come out, and then it gets launched. So you can see how there's two different approaches from a business strategy to this. From a legal standpoint, I'm sure you've all heard about this, is NDAs, or non-disclosure agreements. That's the standard document that you would use to essentially ensure that your information is treated in the way I've set out about. And it's one of the most basic documents that most startups will be asked to execute early in their development. And it is a standard document, but you also have to be careful because NDAs do sometimes have provisions in there that can cause problems for your IP in the long term, and they're very easy to have reviewed by someone, or at least educate yourself on them. So don't just sign them. The minimum thing I thought was at least read it. A lot of times big companies will present an NDA to you and say, this is our standard form NDA, and I've seen cases where they present it as a standard form and the startup doesn't look at it, and in fact what it does is it only protects disclosure from the big company to the startup, as opposed to being a mutual NDA, which is protecting your disclosures as well as theirs. So just be a little bit careful with NDAs. So what's the benefit of startups? Well, the good part of it is that nobody knows what you're doing, so that's how you keep your advantage. The bad side of it is the cat is out of the bag, and what I mean there, and this is the tip number 2 I'll leave you with today, is that a trade secret only works if you keep it a secret. So if the information is publicly disclosed, or if your product is reverse engineered by a competitor or a partner, then essentially you're out of luck. So you have no way of going after someone for trade secret misappropriation if they reverse engineered your product. Okay, so that's something very important to keep in mind. So it's great as long as you can keep it secret. And the whole notion of whether a product can be reverse engineered or not is something that we look at very carefully when we're advising our clients on their IP strategy. And that brings me to the next slide, which is should you follow a patent strategy versus a trade secret strategy? And so what are patents? Well, patents basically protect inventions. And when we say inventions at law, we're talking about, when we talk about inventions that can be patented, there's certain tests that you have to meet under the statute and case law in order to be able to obtain a patent on your invention. And basically, it's got to be new, and that's where Sunny was talking about. Make sure that you look at what's out there, what the prior art is. In other words, has somebody else come up with this before? Did a professor, at MIT publish a paper on exactly what you think you've invented, 5 years ago, right? So take a look, make sure that it's new. But just because it's new doesn't mean it's patentable. It must also meet the test of non-obviousness. And what non-obviousness test is that essentially, if somebody who's skilled in the art, or somebody who is generally familiar with the field in which your invention is in, they need to apply a little bit of innovation to have arrived at your invention. So it's not an obvious improvement on what's already existing. And the third prong of that is that you have to have utility, or commercial utility. You must have use basically in commerce. The power of a patent is that it gives you a 20-year monopoly on your invention. This is a monopoly that the government basically bestows on you and says, okay, so you've proven through the patent prosecution process that you're entitled to a patent on this invention. For 20 years, you essentially have exclusive rights to practice that invention. And that's probably why people, when they think about IP, they automatically think about patents. And it is a very powerful form of IP. And it's powerful not only because of the 20-year monopoly that it gives you on the invention, but it's also powerful because there's no, as I put up there, no good guy defense to patent infringement. And what that means is that in order to infringe your patent, somebody else should not have, they may not have copied your invention, they may not have even had knowledge of your invention, they may have independently developed exactly what you've developed and patented. It does not matter. You can still win in court, you can still sue them, and you can still prevent them from practicing that invention. So if somebody else is sitting in their garage and you file the patent and you get it registered and they come up with exactly the same thing, they have no idea of your company, they've never seen your invention, you can still prevent them from practicing that invention. So it's a very powerful form of IP. I won't get into too much details around sort of the whole patent prosecution process, but the thing to keep in mind is that first of all, patents take time, and they take money, and they take effort. So if you're going for a full patent application, you got to keep that in mind. You're going to be spending tens of thousands of dollars, and it can take up to 5 years or more for you to actually get the patent registered. Now, keep in mind that a patent system in Canada and in most of the world is a first-to-file system. So what that means is if you've come up with an invention and you wait, and somebody else files a patent on it before you file on it, but maybe you came up with that 2 years before they did, doesn't matter. The patent system does not care who first invented something. It's only about who first filed the patent with whether it is the Canadian Patent Office or the U.S. Patent Office. One of the things we find with a lot of our startup clients that helps them, at least if they don't have access, whether it be to OCE funding or government funding or private funding, and they're looking to file a patent, there is a faster and cheaper alternative, which is to file provisional patent in the patent office. And the provisional patent basically is, in some ways, it's a shortcut on the full patent application. So it's not going to give you all the benefits of a full patent, but what it does is it gives you that first file advantage. So what you can do is you can spend a little bit less money, a little bit less effort, file the provisional with the help of a patent agent, and then you have a year to basically turn that into a full application. So it gives you a little bit of ability to manage your cash flow in the short term. The other thing I want to leave you with is, in Canada and the US, we have a 1-year grace period for patent applications. So what this means is that if you're, and this was really driven from a policy standpoint because of the imperative to publish, in the academic environment. So if you're a professor, one of the things that you get you get basically points on is, how many papers you publish, right? So how do you manage that by basically allowing them to publicly disclose something while also giving them, the benefit to protect the invention that they came up with? Well, we basically give them a 1-year grace period from the time that they publish the paper or publicly disclose the invention, let's say at a conference or a seminar, to file a patent on it. So basically, they're not going to lose the ability to patent that. But that only applies in North America. And so in other jurisdictions, there may have different rules, and sometimes you might be out of luck. One of the tips I want to leave you with, and it's obvious, but sometimes people miss this, is that when you file a patent, a year after you file the patent, it becomes publicly available. In other words, anybody can go on the patent registry and search and see the contents of what you've disclosed on the patent. So in other words, it's public information at that point. So the important point there is to realize that you want to really think about not only what you patent, but also understand that once it becomes publicly available, it's up to you to monitor and to enforce your rights. So if you're looking to prevent other people from practicing your invention, they have access to it. So the government says, I'll give you the patent, but you got to go out and enforce your rights. So that's something that people sometimes miss, and they think, I've got the patent, so I'm good. Patent is only as good as your ability to enforce it. The other thing I want to talk about is basically two prongs of patent strategy. And this goes back again to my point about thinking about IP really as part of your overall commercialization toolkit. So why do you even want to get a patent, right? And so I think people sometimes will go ahead and file for patents and before they even know what their business is going to be. So when you look at, in general, people's approach to patenting, you have basically an attacking or offensive strategy, and then you have the defensive strategy. In terms of the more aggressive patenting strategy, you see companies, for example, in the States, which people will refer to as patent trolls, which are companies which will essentially come in, they'll buy a patent portfolio, and they're just going to go out and essentially sue and monitor. So they're going to go out and monitor and say, okay, who's practicing this invention? We're going to go after them, sue them, and obtain damages or royalties, fees essentially from the patent portfolio that we hold. There's other companies, of course, who are just really looking to generate revenue from the patents, but they're not really considered patent trolls. They're just companies that innovate, they develop inventions, they get patents on them, and they look for basically applications or markets or partners who might want to use those patents, and in exchange they generate revenue. The defensive strategy, and the best example of that is, of course, I'm sure you've all been following the news, is the acquisition of Motorola, the Motorola mobile business by Google. That's a perfect example of a defensive strategy. And I put a little link to a Globe and Mail article which covers this very nicely, and not only because they quote me, but really it is a good article. But when you look at what drove Google to that acquisition, I think a lot of people would agree that it was really driven by IP and patents. And what they wanted to do is they wanted to protect essentially the Android operating system against the somewhat aggressive stance that Apple is taking in terms of the iOS and sort of attacking whether it's tablets or phones which are running Android for patent infringement of the iOS operating system. And so the idea there is basically you're acquiring these patents so that if you get sued, so if let's say Google or a device manufacturer gets sued by Apple for infringement of the iOS, that they have a patent portfolio that they can look at, and perhaps Apple is infringing on some of their patents. So it basically provides a little bit of leverage or something to bargain with. The last tip I want to leave you with in terms of patents is, again, just think about patents as part of your business strategy and as part of your overall commercial toolkit. So think about essentially, why do I want a patent? Okay, and how is this going to fit with my overall business plan? The last sort of kind of IP that I want to talk about, which people sometimes don't really tend to think about, is trademarks. And trademarks are essentially a legal means to protect your brand. So whether it be the name of your business, the name of a product, so Microsoft or Windows, or it might be even a logo. So let's say the Nike little swish mark. That's a very famous trademark. And what trademark registration gives you, and it's very similar to patent registration, so it basically gives you protection over that particular brand at a country level. It is similar to patents. It's a first to file system. And if you think about some of the dangers of issues that trademarks can cause for you if you don't look at them carefully from the get-go, is think about what happened with the iPhone's introduction in Canada, where Apple was basically mired in a legal dispute with Comwave, who held trademark rights to the name iPhone. And so they were the first ones who had filed in Canada, and they were using that brand. iPhone was entering into the Canadian market, and were it not for, they basically reached a deal to acquire those trademark rights from Comwave. But that was certainly a hurdle that they had to jump over in order to enter the Canadian market. So trademark registration basically gives you the ability to protect your brand long term, and also ensure that you actually have the rights to use that brand. The tip I want to leave you with on trademarks is just try and sort of look at trademarks as part of your overall branding strategy. So before you spend a lot of money on building, kind of getting your domain names and sort of building up and investing in your brand and your marketing materials, spend some time getting some advice to make sure that, actually the landscape is free and that you can actually go out and use this brand. Because otherwise, you're building up all this goodwill behind this brand, and if you don't have the rights, if there's an existing trademark, then you may run into problems in the future. So that's my talk. Happy to take any questions. Yes?
If I have an idea, can I protect it? I mean, I know that there's no way I can implement it because, I don't have the wherewithal or the size to do that. But can I still protect my idea? Like if somewhere else to come along down the line, I can benefit from having that idea. First person to think about it.
Okay. So now I'm wondering whether you were napping during my presentation. I'm bugging you. As I mentioned in my presentation, there's really two ways you can protect your idea, right? It's either through trade secret protection, which basically means you don't disclose it, or you can disclose it very carefully with all those various mechanisms and protections that I mentioned. Or you look at obtaining a patent on it. If you're really concerned that somebody else may come up with the same idea, or if you put out your product, somebody might be able to reverse engineer it, then you should look at a patenting strategy.
But idea is not a process or a product. Idea is just, it's just an idea. It's a vaporware for all you know.
Well, so are you arguing against the value of your own idea then?
No, what I'm asking is, patent only applies as far as my understanding is concerned to something that is tangible or.
Okay, so let me clarify that. And for those of you who want basically a more detailed, I only had half an hour to cover IP in general, but if you're looking for a more detailed analysis, I speak every year at the Modern Entrepreneurship 101 series, and there's a video clip of that, and that'll provide you a little bit more detail on different forms of IP. But talking about patents, patents do cover intangible things as well, right? So right now we have actually, decision should be coming out shortly, but we have a case with Amazon going to the Federal Court of Appeal in Canada on the whole one-click ordering process, or business method patent that Amazon had obtained in Canada. And so, in the States for many years we've had business method patents as well. So it doesn't have to be a tangible physical thing that you can touch. There are software patents out there, and we all know that software is not tangible. But having said that, you have to fall within, under the umbrella of patentable subject matter, right? So patentable subject matter is, either a product or a machine or a process, or a composition, like a chemical composition. So you have to fall within one of those categories or one or more of those categories, and your patent agent can help you figure out, in your case, your particular idea, where can it fall and how can they help you to get a patent on it.
Thank you.
Arshia, I think for the benefit of the group here, can you just talk about the financial impact of having a patent portfolio when a company exits?
Mm-hmm.
Like one versus a, 2 or 3, and just talk about what the
Absolutely.
valuation would be.
Yeah, so it's interesting point. If you look at, for example, Google's probably an extreme example, but by some measures they were paying up to $500,000 per patent when they acquired Motorola. So now, having said that, that depends on what use or how is that, what use do they want to make of that portfolio, right? So in Google's case, they really almost had run out of options. They had to buy the stuff from Motorola. It was either them or RIM, essentially, right? Because they didn't really get anything out of the Nortel portfolio. So that was almost like a, bet the company or protect Android and their whole business strategy on mobile devices. So there was a big business impetus behind that. But in general, yes, they are a powerful form of IP. But what I tell my clients is, and again, this really differs industry to industry. So let's say if you're a pharmaceutical player or a life sciences play, you're going to spend up to 80% of your venture capital financing that you raise obtaining patents, because that's really what the company is built around. If you're a software company, for many years, I know one of my clients, the most successful software entrepreneur in Canada, Bill Taven. He doesn't, him and his CTO and the team there, I mean, they like patents, but them and with a lot of other people in the software industry don't really think very much of patents in software. I mean, they actually think that there's tons of patents that have been issued on software inventions that really should not have been issued because in their mind they've always existed, and or they think that really building a software company is more about execution than about spending money on patents. But that's even changed now. So you see, companies like Microsoft and Apple and Google spending a lot of money on these things. I'm of the opinion that you really have to think of it in terms of your overall business strategy. And my concern a lot of times with my clients is, I don't advocate against patents, but I think, particularly in the IT industry again, I'd rather my clients spend a lot of time building their business and building products because it can take away a lot of time and energy, right? So, and also cost. So if you're looking at it, and I've seen a lot of my clients who spend tens of thousands, hundreds of thousands of dollars on patent sort of prosecution, and then they've had to abandon one or more applications, and it takes time away from their focus on the business. But again, it's really on a case-by-case basis, and that's a point that I want to leave everybody with, is that all these forms of IP, you really have to look at it being customized to what is it that you're trying to do, right? There might be cases, maybe there's a software play and it's come up with some very innovative database design to increase efficiency of searching on databases. If that's a pure technology play, yeah, you're going to spend a lot of money going after patents, right? But if you're doing a web mobile player, or let's say you're taking some CRM software and applying it to a vertical, maybe you want to apply for one patent, but that's not really going to be crucial to your business. So you really have to think about what is it that I'm trying to build here and what is the value of the company. Yeah.
In terms of searching for patent, like have an idea now, and it's about searching for patent and trying to find that it's actually, whether or not it's available, like how do you go towards that? Like, because it's very specific what you're doing, and another patent could kind of cover that in a different route, but as opposed to the route that you're going through.
Yeah. So it's a good question. So that's kind of what patent agents and search companies specialize in. Because you're going to search a registry, the patent registry, and you're going to hit 500 patents, and you're, well, how much time do I have to sit down? So, you got to work with professionals, and the important thing when you work with a patent agent is to ensure that they really understand your technology, and so you'll see, we provide, patent prosecution and patent searching as well, but we're primarily focused in, mechanical, electrical, software, those kinds of things. We don't do pharmaceuticals because we don't have somebody with a PhD in chemistry in our office. So we want to really look at somebody who has a technical background because that will help them frame how they search the registry and how they filter through that. But it's something that, at the end of the day, there's some amount of work that you can do on your own, but it always helps to have a professional do that for you.
So I have one other follow-up to that. I know how you mentioned that it's the first to file method. So if I file the patent and you said it becomes public after a year.
Right.
Now, what about somebody else did a patent before that year or in between that year, and it's not public? How would I know about it?
You wouldn't.
Okay.
No, that's a very good question, and that's what we also, when we do patent searches, right, as sort of Sunny was saying, you do a prior art search, or we search a patent registry and we say, okay, looks like this, this is, as I say, like a virgin market, or sort of not a cluttered landscape, and so you can actually enter that market or file a patent on it. We always premise that by saying, there could be stuff that still is non-public, and we will not know that until it becomes public, right? So you always have that risk.
I must thank Arshia for such a fascinating talk on using trademarks, trade secrets, and patents as a commercialization strategy. I do need to squeeze another speaker who I didn't know was there. You can ask the question during the panel discussion, please. Thank you very much.
Thank you.